module covers contract formation, claims for breach of contract, and remedies. We'll begin our study of contract law by learning the elements of a valid and enforceable contract. Every contract requires an offer and acceptance, which are called the agreement, consideration, a legal purpose, and contractual capacity. If any of these requirements are not met, no contract exists. If the offeror or offeree are more than one person, we call this a joint obligation contract. For example, if 4 college classmates decide to rent an apartment together and they sign the lease agreement with the apartment complex, they formed a joint obligation contract. Liability under such a contract may be joint or several. Joint liability means if one of the joint obligors fails to perform, the others are liable collectively for that person's obligation. Joint and several liability means that if any one of the obligors may be held responsible individually for 100% of the liability caused by any of the others. Third-party beneficiary contracts are created for the benefit of someone other than the offeror or offeree at the time the contract is made. Third-party beneficiaries have rights under the contract and can sue for breach. A common example of a third-party beneficiary contract is a life insurance contract. The contracting parties are the insurance company and the insured. The beneficiary is the person who will receive the proceeds upon the death of the insured. An assignment is a transfer of the benefits of a contract to a third party after the contract is made. The assigner has to give valid notice of assignment to the other party. The most common example of an assignment is the right to receive payment under a contract. If a person assigns his right to receive payment to a third party, the person who owes the payment must pay the third party instead of the original party. A delegation is a transfer of the duties or obligations of the contract to the third party after the contract's been executed. For example, if Janie's Catering is supposed to cater a coffee break at Acme Corporation, but Janie learns she has a conflict that day, she can delegate the duty to perform to Sheila's Catering instead. A popular misconception about contracts is that they have to be in writing to be enforceable. Most of the time, a verbal contract is just as enforceable as a written one. However, there are a few categories of contracts that must be in writing and signed in order to be enforceable under the statute of frauds. These categories include contracts involving an interest in land, contracts that by their terms cannot be performed in 1 year, collateral or secondary contracts, promises made in consideration of marriage, and contracts for sale of goods in excess of $500. Contract cases are decided under an objective standard, meaning that a reasonable person in the position of the parties would have assumed the contracts to mean. This is important in determining the existence of a contract as well as whether it has been breached. Most contracts are discharged by complete performance. However, where a party fails to perform according to the terms of the contract, a breach occurs. If a breach of contract is material, the other party is excused from performing his end of the deal. Where there has been substantial performance in good faith, the innocent party is not excused from performing, but can sue the breaching party for damages for the difference between the promised performance and what was actually performed. A party may have some defenses to a breach of contract claim, including mutual mistake, fraud, undue influence, duress, or the statute of limitations having run. If the breaching party has no defense, he may owe compensatory damages, consequential damages, or nominal damages, but he probably will not owe punitive damages.